Today I'm talking to you about The New Jim Crow by Michelle Alexander. The book has a full title about mass incarceration in the age of colorblindness. And so today we're going to use the theme of law and society, where we analyze the gaps between law as real and law as the way that it's supposed to be, or what people call as ideal. To analyze this concept of mass incarceration and whether there might be something beyond just what people say, justice is blind. So the title here is Thesis in Legal Cases. So I'm going to give you her thesis of her book, and then also give you the historical line of legal cases, some of which she mentions in her book, others that I'm giving you as outside sources. So Michelle Alexander is a law graduate. She's worked in civil rights law for a number of years. And she noticed in both her work as a lawyer and in her legal research that people tended to look at the issue of mass incarceration as if it was race neutral, or as if there wasn't a discriminatory practice towards people of African descent. One way that you can also think about the thesis, in addition to reading the book, is to see what other scholars write about her. So I have given you one of those scholarly articles that provides a review of the book. And that PhD gave this as the thesis. So Alexander analyzes the several hundred of years of variously oppressive race relations between whites and blacks in the U.S. She identifies a sequence of forms of social control which were refashioned to the new tenor of the times. So, in other words, after slavery was socially unacceptable, with the Emancipation Proclamation and the end of the Civil War, people with racist intent within the political and legal system then refashioned the tools, used the system itself to continue their ideas of racial supremacy, of hierarchy, and of discrimination. So they also highlight this important point about her book, which is that the problem is not that drug offenders face problems of re-entry into society, but rather the convicted offenders are boxed in and therefore forced out from legitimate relationships within society. We'll talk about this a little bit later, but you'll hear people say, the problem is not crime, is not policing, is not the correction system, but is rather one of a larger social force, that being poverty, lack of education, or that criminals learn their behavior in prison. We'll understand a little bit later why that is called a red herring or a false argument. But the point here is that it's the criminal law itself and the policing of that law which is excluding people from society, forcing them out, and that's what she means by boxed in, right? That there's no way to get out. And so it's really a social issue that is a use of discrimination and not just something that kind of happens. So in the politics of legal exclusion, we think about Dr. King, and this is a good example here in the video of Eric Gardner, right? And you'll notice that the guy who's actually plainclothes cop, right? He's the one who actually does the illegal act of the chokehold. But what you want to think about here is that why was Gardner targeted in the first place? So Dr. King wrote about this idea of difference made legal, which is where I'm forming my idea of the politics of legal exclusion. And politics here is the struggle for power, right? So an unjust law is a code that a numerical or power majority group, a majority group in this case being the white population in America, or a numerical group could also be, right, the majority population of white America. So it does, power here, as you see, is the police, right? They are the power group, okay, but they're backed up by the majority group, okay? And this is when the majority group compels a minority group to obey laws or the code, but that they don't make binding on itself. And this is what's called difference made legal. So you think about the way the police conduct themselves with people of color versus white people. Okay, the way in which the judicial system punishes black people more than it punishes white people, especially for drug crimes, or when police officers look the other way. But also in the criminal law itself, right? Who is it targeting? And then who gets to participate in the electoral process, and at what percentages, how are voters pushed out of the system, etc. So King also kind of took that to the next level by saying a law is unjust, right? And therefore we have a duty to disobey that law, right? And to try to change that law if it is inflicted on a minority that, as a result of being denied the right to vote, which is a historical legacy to people of color in the United States, as well as women and children, to that matter as well, had no part in enacting or devising the law. So in other words, the power group or the majority group passes a law that simply applies to a smaller group. And then they don't apply that law, or they have no interest in following that law themselves. So if we think about cases then, and later I'll show you some historical examples, but first I want to show you kind of a great example of modern times. And here you'll see that there are 3 Supreme Court justices, Brennan, Marshall, and Stevens, and that's Thurgood Marshall of the Brown versus Board of Education case. He later became a Supreme Court justice. They voted against this ruling, okay? And so that leaves a majority here of 6, and you'll notice that they're all white people. So the case name is Hutu versus Davis in 1982. Now, I'm going to highlight the bold part first, okay? So here they're saying, and this is the holding of the case, the important part of the case, the federal courts should be reluctant to review legislatively mandated prison terms, especially by states, and successful challenges to the proportionality of particular sentences should be exceedingly rare. Now, proportionality means that the crime and the punishment fit each other, right? So in this case, they don't, or at least that was the claim by civil rights lawyers, that possession of 9 ounces of marijuana, which most likely means that the person has intent to distribute. It's not necessarily true, right? You have to have other evidence to support this. Does not match the 40-year sentence that the person was given simply because Virginia had that punishment. Okay, other states don't have that punishment. In fact, today, New York has a 3 to 5 year punishment. The Court of Appeals in that case sanctioned an intrusion in the basic line drawing process that is properly within the province of legislators, not courts. In other words, okay, what the court is saying there is a separation of powers or divided powers argument. That the courts should not overturn state laws even if they are unjust, even if they do conflict with modern conceptions of civil rights. I want to highlight that this is a matter of interpretation. In other words, this is an interpretation of the law, an interpretation of philosophy of law, and of the Constitution. It's a choice that they made, right? And that's why the other 3 individuals didn't make that same choice. In fact, Marshall and Brennan famously thought that if a civil right had been taken away from you, it was their duty to restore it to you as quickly as possible. Okay? However, the other 6 did not believe that. Okay? They didn't want to question the state of Virginia, regardless of its intent. This brings us to a concept called originalism, and this is what the majority of the Supreme Court argued here. They've argued it before, and I'm going to show you that in the next slide. But most recently, you had the Supreme Court justice that was just nominated, who replaced Antonin Scalia. He also believes in this concept, at least according to the media, of originalism. And the meaning of originalism, or the way that they define it, is they say that the only acceptable method for interpreting the Constitution is to apply a quote-unquote text and original meaning of various constitutional provisions. Now, if you were to take any religious document, such as the Torah or the Bible or a Quran or whatever the Vedas, right? Any other concept within religion, right? That's been written down, you'll see that if you had 10 people in the room, 10 people will interpret that document differently, right? There's no single way of understanding any sentence within any book. Now, some people will organize groups, right, and philosophies and ideologies that say that their way is the only way of understanding it. And generally, as Americans or Democrats, right, in a democracy, We don't really go for that very often, right? You'll hear people, that's just your opinion, okay? So certainly some things mean what they mean, right? So if it's raining, we know it's raining. But how is it raining? What kind of rain is it, right? Is it that kind of rain snow that sometimes happens? Okay, so there's always a matter of interpretation that's open to individuals and groups. And then ironically, there's no prescribed method for interpretation by either Congress or the Constitution. It doesn't say anywhere what lawyers and judges are supposed to do when it comes to reading that document. So other methods involve a living constitution, which Justice Ginsburg talks about, active liberty, which puts a particular emphasis on democratic participation. That's from Justice Breyer. Oftentimes, judges will look at congressional intent, right? So usually there's an intent statement by Congress or a legislative body that says what they meant by the law. Or more commonly, in the common law history that goes all the way back to the Magna Carta in England, you look at things from a case-by-case, or stare decisis is a Latin term for it, which kind of gives you an idea of how things can develop over time. Okay, so things can change a little bit based on the customs and habits of that particular group of people. So now we look at the historical line of cases that promote racial hierarchy or racism. And these are all built on the idea of originalism, or what the founding fathers meant. So it begins with the slavery constitutional compromise. So in the 1780s, when they were arguing about slavery in particular, you might have learned, right, that some people in the North were against slaves, and those in the South, many of them South Carolina, Georgia, Virginia, right, they were for the importation of slaves. And this was a real sticking point for the 13 colonies as to ratify the Constitution. The South didn't think the North should be able to tell them what to do, and the North didn't think that this was a good example of what a modern government based on freedom and liberty should look like. So they came to what's known as a compromise in business and law, right? Which means that neither side gets what they want. And they said, James Wilson wrote in the Anti-Federalist Papers, wrote that in 1808, this is a clause that goes into the negotiation phase of the Constitution back in the 1780s, that in 1808, Congress will get to decide whether they want to ban the import of slavery, and in fact, they can tax the states that decide to import slaves. Now, in 1808, they didn't pass this law. They kept compromising and kept compromising and kept compromising all the way to Civil War. And so during the same time as the Civil War, okay, Scott versus Sanford is a case where Dred Scott, who thought he was free, had been freed by his former slave master, had gone into a state, Missouri, that had not recognized the power of the federal government to free slaves. And the Supreme Court, in that case, right before the outbreak of what we mostly know as the Civil War, right, the big actual fighting, said that people of African descent were never intended to be citizens and never could become citizens. And that was based on an original interpretation of the Constitution, meaning that because the original Constitution did not say that people of African descent could be citizens, then they ruled that they could not be. So this continued, even after the Civil War, even after the Emancipation Proclamation, even after slavery was banned in the 13th Amendment. 30 years later, 35, 40 years later, after the Civil War, there's a case called Plessy versus Ferguson, in which a train had ordered people of color or non-white people to use separate facilities on a train. So in that case, they said, of course, famously, people remember sometimes incorrectly, but in Plessy versus Ferguson, they said separate but equal, meaning that if you're on the train, you can't complain. Maybe you're having to sleep with the animals, right? The cattle. Maybe you have to get cramped into a closet with storage containers while the white people get to sit up front and have a nice, comfortable time, get food, drink, all that stuff. But as long as you're on the train, that's equality. That was equality to them. Again, this goes at an originalist interpretation, basically, which is saying people of color weren't intended to be a part of this American society, and so then, what can they possibly be complaining about? Then a little less known, right, is the case in the 1950s, okay, again, brought by Thurgood Marshall and his team in 13 different jurisdictions in the South. And in that case, people remember the phrase, separate is never equal. right? However, that case stands for, the holding in that case was that segregation or separation of people based on the color of their skin harms children, that it has an actual long-term psychological and physical harm on children. And so the Supreme Court ordered that schools be integrated. Now, they never were. And you can see a New York Times segregation map if you go online. And you'll see that New York City actually has the most segregated schools in the history of the United States. Okay? Now, people say, wait a second, I went to school and it was very diverse. Diverse and segregation are not the same thing, right? Segregation is when white kids are separated. So in other words, you can find schools in New York, oftentimes private schools, where the overwhelming majority of that school is white. Now, another issue is who gets to define white in America. There are many people who say that Italians are not white, that Jewish people are not white, that Irish people are not white. Now, this can be very confusing, of course, but you go back to that power group, right? The power group, politicians, judges, etc., through the law, through politics, and through social institutions, they're the ones who decide who gets segregated, who gets discriminated against, who gets excluded legally. Okay, and so if you think about diverse schools here in New York City, they are often very diverse, right? But they lack, right, the inclusion or the integration of what the power groups consider white, which, you know, today would be probably wealthier kids, right? Wealthier white kids, maybe like the Trumps. Okay? They get to have their own separate education system, oftentimes private schools. This then creates this kind of separation through the law of society and social relations. It isn't surprising that after that time, right, the 1950s, as these tensions start mounting, the civil rights movement begins, the 60s is when it explodes, that this case comes out, Terry versus Ohio. And if you haven't read this case, you know, as a criminal justice student or law society student, it's important to read this case. The Supreme Court decided in that case that the police, right, not judges, not politicians, not the people, not the Constitution, not the Bill of Rights, but police individually and as groups, which are often of the power group, right? They're the ones with weapons, and they're often from white communities. They get to decide who is dangerous in all communities, everywhere in the United States. And so they use this kind of language, and you'll remember that upon probable cause is the language that they use in the Fourth Amendment, but the court invents a new language here, that reasonable suspicion. So if a white police officer thinks that a person of color is reasonably suspicious, you know, they can stop, interrogate, arrest, torture, murder, right? They can do whatever they want to them because they get to decide who is dangerous. This is kind of the nail in the coffin or the icing on the cake, right? If you go back from the slavery, constitutional compromise, right, where they're not going to end legal discrimination, go through the cases all the way up to today, you can now see, right, that police are simply doing what the power group has wanted them to do this whole time, and now they've been able to figure out how to do it politically and legally. So now we have a historical narrative, and the defense that you'll hear people use, or especially police officers and judges and politicians, is that, well, you know, the state has a right to defend itself. Now, this is confusing if you went to elementary school, right? Because you will remember that the government is of the people, right? So we have a right to defend ourselves, right? Against the state is the concept in the Bill of Rights. It's the whole point of the Second Amendment. In fact, in the Declaration of Independence, this was the argument that they used against the government of England, that they had a right to defend themselves against the government, against the state of England. But it's beginning in World War I where this really becomes clear that the Supreme Court has a different view than what the basic building blocks of democracy were. And that's called Gitlow versus New York. And this guy wrote a pamphlet in which he said that the government had been taken over by rich people and that it was only for them, and that it was being used to abuse poor people. And he was arrested. And he said, well, wait a second, don't I have a First Amendment right? And the court said, well, the First Amendment can be limited, right? The court and the police get to decide whether you're a threat to the state. Now, even though he didn't have a militia, he didn't have any guns, he didn't have anybody following him, he just simply had wrote a document, right? They put him in jail. Now later, after the civil rights movement starts moving and people start thinking about individual rights again, right, like they hadn't for about 200 years, there's a case called Griswold versus Connecticut where they said some rights are natural, right? They come outside of social government. They come outside of these relationships, right? They're things that you would have if you were just wandering around in the wilderness. And they're so fundamental that nobody can take these away from you, right? Liberty, life, sometimes pursuit of happiness, right? Depending on what you mean by that, okay? Property, okay? These are so fundamental that you would defend your life for these things. And that these predate the Constitution, meaning that they were there before the Constitution, so you know they'll be there long after the constitutional government is gone. You see this like defense of itself again come up in the World Trade Center attack and really excessively since then. But it's old rhetoric, right? It's old words, old verbiage. And these phrases are always the same. Law and order, tough on crime, right? It's always used to create this in-group, out-group scenario, right? That you're in the in-group and somebody else is in the out-group. So we need to be tough on those other people because we must be good people, they must be bad people. Law and order is a particularly confusing phrase, right? Because they say on the one hand, right, that we need to have law and order, right? Sometimes referred to as rule by law, not rule of law, rule by law. But then you see they'll ignore this crime over here, or this person will, be convicted of a crime, and then they'll pardon them, like Trump did with the sheriff from Arizona. They don't look at financial crimes like in 2008 with the collapse, and you see people steal money all the time, and you can just have a settlement, right? So this law and order and tough on crime is very specific, right? The power group gets to decide who they're going to be tough on. Now you're seeing this be used against immigrants, which immigration is a civil issue, right? Like getting a driver's license. There's no criminal law involving immigrants, right? It's the same, right? If an immigrant commits murder, it's the same as if a resident or citizen commits murder. You're charged with the exact same crime. But now you see this same power group, this racist hierarchy, trying to use this now in the area of immigration. And Trump does this on a weekly basis, really, but he's not the only one, right? You can see people on both political parties, frankly, using this term illegal immigrant, right? There's no such thing. You can look all throughout the law and you'll never find it. Doesn't mean that they won't pass that law, but again, that would be an unjust law. That'd be a law that applies to one group but doesn't apply to everybody else. So Michelle Alexander has 3 stages that she sees, and then I give you kind of the historical narrative again. And this comes in chapter 5. This is where her thesis is most pronounced, and it's on 185 to 186. So stage 1 is the roundup, where police officers in the law, right, go around and they round up people that they find to be the target group, right, who they're trying to get rid of. And that starts again in Terry versus Ohio, where the Supreme Court gave that power to the police. Stage 2 is formal control, which is prisons, private prisons, state prisons. People can now make money off prisons. And this is formal control. And that says, if a state decides that they want to lock up a certain group of people, who are we? The law, the judges, who are we to tell them that they can't do what they want? Now, of course, if that was true, right, there would never have been a civil war. Right, that we go right back to that same argument, right, that if somebody wants to discriminate against somebody else, I guess we should just let them. Stage 3 is an invisible punishment, right? This is when felons get the right to vote taken away, parole, all sorts of monitoring devices, not be able to get a job, etc. This is this invisible punishment after you've already been punished once. You've already been through prison, now you get another punishment. But again, you see this very clear in Scott, Plessy, and Brown versus Board of Education. The power group has decided that this other group is excluded from politics. They're excluded from law. They're excluded from social relations. So historically then, slavery ends, the criminal justice system begins, police get to use their discretion, the prison industrial complex houses all of the people that the police decide are threats, and then felons lose their rights, right? So this permanently keeps them out of the process. Now, it's counterintuitive, meaning that, you have to think about it for a second, and it's an abstract concept. It doesn't seem like it makes sense, but if you think about it, it makes perfect sense, right? There are no crimes without law. And the more crimes you have, the more crimes that are passed, okay, more crime laws that are passed, the more criminals you will have, and then you'll need more police to go round these people up. So laws and police cause crimes, not poverty, not ignorance, etc. Poverty and ignorance have been around for 10,000 or more years. Law, criminal law, and police, however, have not. Okay? So the other idea that people might throw out is, well, prisoner reentry programs are the way to go. All right, we just need to educate people after they get out of jail because they've been socialized a certain way. It's a little confusing if you think about it because I thought the whole argument for putting people in prison in the first place was that they were antisocial, or they were sociopaths, or they were dangerous, or it was, so how did they become more dangerous or differently dangerous in prison, and then who's responsible for that? Okay, so you have to think about this as a very contradictory concept to begin with. So prisoner reentry programs are trying to fix a problem by not addressing the cause of that problem. So it misses the point, right? They might be helpful to a handful of people, but unless you're going to change the social system and unless you're going to actually target racist people, then you're not really changing anything. The underlying causes continue to exist. So the thesis again from Michelle Alexander is that convicted felons enter into a separate society, hidden from public view, governed by separate discriminatory rules and laws that do not apply to everyone else. So some people say, well, this is nothing new. Well, it's true. It's not new. This has been a historical problem, right? There's been race difficulties for a long time. But now racism is more efficient and organized because it's controlled by the state, through justice, through law, etc. So other people will say, well, this is just, justice is blind. People are committing crimes and therefore they should get what they deserve. Well, unfortunately, that's not the case, right? This is a group of people who have bad intent, and they're colluding, they're working together, not by accident, but intentionally, as you can see more and more in the social media today. They're not colorblind. They're going after targeted groups, and they're specifically ignoring people of their own group. Now, this brings me to the final point, right, of the problems, is that those who do nothing are on the side of those that harm. You have a majority of white people that simply say, well, this has nothing to do with me, right? But a threat to justice anywhere is a threat to justice everywhere. So if the state gets so powerful that they get to decide who's a threat, they get to decide who goes to prison, and we have no more rights, then who's to say they're not going to go after you? But more importantly, just sitting on the sidelines and doing nothing is not working against an unjust system, and therefore you are on the side of those that are unjust. So finally, we think about solutions. Derek Bell was a PhD years ago that wrote this idea called interest convergence theory. And we need to get past this idea. We need to get beyond this idea. The basic premise was that white people would only work with people of color when it suited them, when it benefited them in some way. I'm sure that's true of most people, but we have to figure out a way to get beyond that, right? Again, in a social relations situation like a government of all people, by the people, then we all have an interest in each other, regardless of what our social background is. Second, we need to identify socio-legal language of racism. Illegal immigrants is racist. People like them is racist. Even thinking about the words criminals, felons, right? These are very difficult terms to define, right? And they're very contextual depending on what the crime was. What jurisdiction were you in? What state were you in? Did you actually have a trial, right? So we need to think about these terms, not make assumptions and not use stereotypes, and really challenge the language itself in social legal relations. Third, we need to re-examine what is collective constitutionalism. In other words, what is this situation of separation of powers, divided powers, checks and balances? These are clever sayings, but what do they really mean, right? What does it mean to be under one law? Who gets to participate in making the laws? Is it just a handful of people? What do they look like? Where do they come from? Should the law apply equally to everyone, or should you get to just target certain groups? What other social issues are involved? Are these based on people's particular religious beliefs, etc.? We have a collective of different beliefs, a collective of different types of people, different cultures. So how can we design a constitution that covers everyone equally? Fourth, we need to expedite 14th Amendment claims of legal exclusion. If somebody's bringing a claim that they've been discriminated against under the law by a political organization, by a judge, by a lawyer, by a police officer, those should move to the front of the list. We should obviously put more resources and energy to trying to stop, right, the abuse of power by the state, by police officers, etc., and bring those claims quickly. Let those claims get to trial quickly. Next, we need to think about this concept of divided power, right? If interpretation includes racism, and if racists get to be decision makers within politics, judicial activism, police situations of brutality, then we're just dividing justice, right? If power doesn't get to be universal, if it's not applied equally, then it's divided, then certain people who have the power are going to win over and over and over again. And just saying that there's justice or that justice is blind is an empty phrase. It's a platitude that means nothing, right? So we need to think about this concept of divided power, divided justice. Finally, we need to think, right? And I mean this deeply, right? Spend some time thinking, what is the purpose of government? At the time of the formation of this government, those who participated in it argued that the purpose of this government was individual liberty, to be free from people who would harm you, including the state and the government, right? That you should have the right to pursue your own life, that you should be able to be happy, get property, have your friends over, right? Have a family. This obviously doesn't seem to be the purpose of government anymore. And so more and more, right, we need to think, what is the purpose of modern government? Is this what we signed up for? Again, just to review, that this was Michelle Alexander's book, The New Jim Crow, which she contends that colorblindness is part of the problem and that we need to see that there's an actual organized, efficient system, okay, that starts after slavery that continues to promote racist or discriminatory practices over time.